State? That should be done. All right, thank you. I've been taking notes of the information I've received today. I read all the letters that were submitted to the court from both sides prior to court today. I've fully studied out the statement in advance of plea. I also went over my notes from the preliminary hearings in this matter to make sure my memory was correct.
In your Honor, just briefly, I apologize. We would be asking for a continuous protective order.
I've already got that in my notes.
Perfect. Thank you.
All right, thank you.
Right away, you can tell this judge isn't treating this as a routine sentencing. Notice how he emphasizes reviewing letters, prior testimony, and hearing notes. That's important because sentencing isn't just about the crime itself. It's about evaluating credibility, remorse, impact on victims, and the full context of what happened. As this statement unfolds, pay attention to how often the judge returns to the defendant's actions after the crime. In court, what someone does afterward can be just as revealing as what happened before.
The court cannot add to what was said by Mr. Estelli's family members today to describe the type of person that he clearly was. As time passes, I hope that his family will be able to only recall the good memories that you have of him, and that you'll be able to put behind you the tragic events of July of 2024. I'm sure that will take time.
Is a powerful shift. The judge is directly rejecting the narrative presented in the letters of support and reframing the children as victims. That's a significant legal and emotional point. Sentencing hearings often become battles over character, but here the court is making it clear that the long-term impact on the children outweighs claims about parental love. What do you think carries more weight in a case like this, someone's words, or the consequences of their actions?
I hope that can occur. Mr. Estelli, what struck me in the numerous statements in your letters of support that I received was that you quote-unquote loved your children. That's simply not true. Your selfish actions show that you didn't love your children at all.
Here's one of the most damaging findings in the entire hearing. The judge openly states that he does not find the defendant's claim credible. Credibility is everything in a courtroom. Once a judge concludes that a defendant's explanation doesn't match the evidence, it can dramatically influence sentencing decisions. And notice the focus on the Discord messages and post-crime behavior. Those details appear to have left a lasting impression on the court.
Made them victims. Let me be clear. Your children are victims of your actions. They'll be lifetime victims of your actions, and they deserve to grow up without you in their lives. Your actions the day after the events of July show how callous and uncaring you were towards your children and what you did to their father. You tell me in your statement of advance of plea or your pre-sentence report that you wanted to back out of the plan to kill your husband. Yeah, hours after their father was killed, you were preparing for a date, according to a friend of yours from Discord. And you were showing off the scene of a crime to those friends like it was a trophy. When you received condolences from a friend of yours from Discord, you said, quote, "It's okay, I'm happy." I simply do not find at all credible your claim that you wanted to back out of the plan to kill your husband after 5 p.m. on the events of July 2024.
Listen carefully to what just happened. The judge isn't merely discussing the homicide allegations anymore. He's addressing claims of domestic violence and rejecting the idea that the defendant was acting as a victim. Legally, that's a major distinction because mitigation arguments often rely on proving coercion, abuse, or fear. The court is signaling that it found the evidence pointed in the opposite direction. That's a devastating conclusion for the defense's narrative.
As Mr. Brown pointed out, the record is clear and unambiguous. You still had ongoing telephonic communications with your husband before the events that led to his death that night. But more importantly, you had more than just hours to do something about that. You had days to stop your family's plan to kill your husband. But you elected not to do anything. It's clear to the court that your statements and actions or lack thereof in July 2024 was not as somebody who wanted to back out of the plan that you admitted to in your statement in advance of plea, but as somebody who was willing to go forward with it and was happy that the events and the plan was successful. I think it's also important to remind you, as the state pointed out, that you had also entered into a plea deal regarding domestic violence, physical domestic violence against Matt. And there's no record that he ever committed any domestic violence against you. Indeed, it struck the court in our preliminary hearings that you repeatedly told the divorce attorney in the state of Utah that he never physically abused you.
This is where sentencing law can surprise many viewers. Even after imposing severe prison terms, the judge reminds everyone that Utah uses an indeterminate sentencing system. In other words, the sentence range is set by the court, but the parole board ultimately has substantial authority over how much time is actually served. It's a reminder that today's hearing is a major chapter in this case, but not necessarily the final one.
So you're not a victim, you're the perpetrator of incredible harm of domestic violence to your children and, of course, to your husband.
And there it is, the sentence. With counts 1 and 3 running consecutively, the court has imposed the most serious punishment available under the plea agreement. Then, almost immediately afterward, we hear the defendant's apology. That creates a striking contrast. The court has already evaluated the evidence, credibility, and consequences, and now the focus shifts to remorse. Do you believe this apology changes how the case should be viewed, or did the judge's findings earlier in the hearing already answer that question?
With those brief facts in mind, I'm going to proceed forward sentencing. I'm going to order restitution. There's a stipulation to $2,500 at this time. Further restitution is to remain open as allowed by statute. It's required by state law. I'm going to order a $53 court security fee for each count. Fines and fees will be sent to the Office of State Debt Collection. I will waive the fine in this matter. Any assets that you have should go to your children for their support and the restitution for them. I am going to enter a continuous protective order. That means you can have no contact with your children directly or indirectly. And if you violate that, new felony charges can be brought against you. By statute, the presumption is that they would run consecutive to your current sentence. As allowed by statute and as required, I will give you credit for time served, which the parties believe is 316 days at this time. I do note that both the state and your attorney have discussed that your offer is based upon your willingness to cooperate with law enforcement. That was reflected in the plea deal that was offered you, which included the stipulated sentence. That doesn't, however, change what you did and how you did it, or what you did during July of 2024 to your husband. For the family, I do need to point out that we have an indeterminate sentencing system in the state of Utah. I impose a range, and the Utah State Parole Board will ultimately decide how much time Ms. Rastelli will serve in prison. As to count 1, murder, a second-degree felony, I impose a statutory maximum of 1 to 15 years in the Utah State Prison. As to count 2, conspiracy to commit murder, domestic violence, also a second-degree felony, I impose the statutory maximum allowed by state law of 1 to 15 years in the Utah State Prison. As to count 3, felony discharge of a firearm, domestic violence, a first-degree felony, I impose the statutory maximum, according to state law, of 5 years to life in prison. Counts 1 and 3 will run consecutive to each other. By stipulation, count 2 will run concurrent. Do note, Ms. Rastelli, you have 30 days to appeal the sentence. On an appeal, if you qualify and request the same, an attorney will be appointed to represent you. Any questions from the state?
Thank you.
Any questions from the defense?
None.
All right, thank you, ladies and gentlemen. This court will be in recess.
Thank you.
All rise. Thank you. You may be seated.
I'm so very deeply sorry for the pain that I've caused. I understand that my apology will never be enough. to heal the hurt that Matt's death has caused and continues to cause. He didn't deserve it. If I had the power to bring him back, I would. I know that my actions directly caused Matt's death. And for my part, I realized the devastation I caused. I didn't think about the pain it would cause. My heart breaks for his children, his family, his friends, and his community. At this point, the least I could do is speak the truth on what happened to give Matt and his family the justice they deserve.
That's it, Judge.
Anything else from the state? That should be one. All right, thank you. In taking notes of the information I received today, I read all the letters that were submitted to the court from both sides prior to court today. I've fully studied out the statement in advance of plea. I also went over my notes from the preliminary hearings in this matter to make sure my memory